Guardians ad litem in Utah, what a GAL or PGAL is supposed to do, and what usually happens instead. In a child custody dispute, the appointment of a guardian ad litem sounds reassuring. A lawyer for the child, someone independent, someone whose only job is to protect the child's best interests. What could possibly be wrong with that? The answer is quite a lot, depending on how the appointment actually functions. First, let's get the terms straight. In Utah, people often say GAL as though it means one thing. It does not. A state-appointed guardian ad litem is generally an attorney from the office of the guardian ad litem, often involved when there are formal abuse or neglect allegations and the parties are indigent. A private guardian ad litem, or PGAL, is different. That's a private attorney appointed in ordinary contested custody and parent time cases. Not always, by the way, but that can happen in these ordinary cases, and the parents pay for the guardian ad litem. In the typical divorce case, when someone says a GAL has been appointed, what they usually mean is a PGAL. On paper, the role is attractive. The PGAL is supposed to be independent of both parents, investigate the child's situation, consider the child's best interests, and give the court useful input. If the system worked that way, a PGAL could be a genuine asset. A careful, neutral, child-focused lawyer could help the court and the parents see what's going on if the parents are being too angry, afraid, or self-interested to see clearly. But in real litigation, the role often drifts into something much harder to defend. A PGAL recommendation can start functioning like evidence, even though it is not evidence. A PGAL may tell the court what the child supposedly said, and what the child supposedly needs, or what arrangement supposedly serves the child's best interest, or what the child even wants. Courts often give that enormous weight, but the PGAL is not treated as a witness. Can't be, it's illegal. The PGAL is not cross-examined. The child's statements are often filtered through the PGAL without ever hearing from the child himself or herself. Interviews with children are not recorded. That means that no one can verify what was asked, what was said, what was omitted, whether the child was led, whether the investigation was competent, or whether the recommendation rests on anything solid. No record means no accountability. It also means little meaningful review later. This is not a claim that every PGAL is lazy, biased, or acting in bad faith. Some do careful work, or so I'm told. The structural problem is that the system permits unrecorded, untested, lightly documented input to carry enormous influence, all under the guise of a lawyer for the child. And the court benefits from that arrangement because it is convenient. It keeps children from testifying, it shortens hearings, it shifts uncomfortable fact-finding away from the bench. But convenience is not evidence, and it is not due process. If a PGAL is appointed in your case, take it seriously. Be honest, organized, and measured. Do not exaggerate, but do not confuse cooperation with surrender. A PGAL recommendation should be held to a standard, a high one. If the court is going to rely on claims about your child, those claims should rest on actual verifiable evidence, not on a lawyer's unrecorded summary that no one is allowed to test.